Hello, my name is Michael Kvistad. I'm a lawyer here at Beresford Booth, and I practice mostly in mergers and acquisitions, which is the buying and selling of businesses. And today I want to talk to you about indemnification clauses, especially in the realm of buying and selling a business. Um, Indemnification, as you can tell from my title, is the clause that writes the check. It's kind of like the empire that strikes back as well. You've sold the business, you're on your merry way, or you bought a business, things are going great. Something happens, that's when the indemnification comes in. It comes in after the fact. And so we're going to talk about kind of what it is and how it can be tailored for various situations. So first off, what is an indemnification clause? It basically means that you're going to reimburse me for any losses. If something happens, you got to pay for it, not me. That's basically what it says. And but what are those somethings? It could be lawsuits that get filed, could be some property damage, could be an intellectual property claim, or perhaps an employment claim. And so, kind of in other words, indemnification is a clause that decides who writes the check when something bad happens. That's basically what happens. And we think of employment injuries, the way this can come up, as an example, is say we're closing on a Thursday. That's when everything gets signed. So as of 5 p.m. Thursday, the buyer owns the business. Seller no longer does. But on Wednesday, the employer gets injured. We're not sure to the full extent, maybe 3 weeks later. So a good 3 weeks after the closing of the sale of the business, they go to the doctor and turns out they've got severe injuries. Who's responsible for that? You know, if there's a L&I claim, who's responsible, the buyer or the seller? Well, indemnification will can help parse that out. And typically it's a seller, but indemnification can help parse that out. So the buyer who's dealt with this L&I claim can say, hey, seller, you need to reimburse me for this injury that occurred on your clock. All right. So I want to also mention, as we go through indemnification, just a couple of terms that come up a lot, and then kind of a few ways that we can kind of tailor things a little more. So when you're reading through an indemnification clause, really on any agreement, if you see the terms any and all clauses, that should be a red flag. That should definitely be a warning light for you, flashing lights, to maybe consult a lawyer because any and all claims can include claims you didn't cause, claims that are outside your control, or even claims unrelated to your work. I mean, it's that broad. So that's often tailored with a um, maybe a clause after it that defines what areas that applies to. But that is something to keep an eye out. Another thing is the duty to defend. Duties to defend exist in all sorts of areas of law. But they can even arise in Washington when you transfer real estate, incidentally. But when we're talking about M&A, buying and selling a business, mergers and acquisitions, a duty to defend means that if a claim arises and the buyer needs to defend themselves and hire a lawyer, that the seller has to pay for that lawyer, even if it hasn't been decided whether the buyer or the seller is responsible. So that can be a big, just a big liability. I mean, it really can. And that's something that can pop up later. So that's also something that can kind of be tailored, minimized, but it is something just to keep an eye out. It's a red flag to keep an eye out if you do see that. Um, so then when we get down more into kind of more M&A specifics things, we talk about baskets, caps, and survival. So a basket is just a threshold that a claim must meet before it becomes a valid indemnification claim. So that could be $50,000. Could say, hey, your damages, you can't file an indemnification claim against the seller unless it hits $50,000. Then at that point you can. Sometimes it gets into, well, you can just get above that 50,000, or you can get your first dollar. Once you cross 50,000, you get your first dollar all the way to the top dollar as a reimbursement through an indemnification. And without a basket, even a small claim that might be, well under $50,000 or whatever the threshold could be, um, that small claim can create a large amount of attorney's fees. So even if though it's small, it could cause costs a lot of money just because of the attorney's fees. So the basket helps protect from that. Another thing, like I mentioned, is caps. It's a cap on liability under indemnification. It's often a fixed dollar amount or a percentage of the contract price. And without a cap, theoretically, your liability is infinite. But with that cap, it's topped out. Sometimes it's the purchase price. Sometimes it's 30% the purchase price, 50% the purchase price. It's some dollar amount. Or if there's maybe a specific liability we're concerned about, it could cover that liability. So there's various ways to do that. Another issue is a carve out, which basically says, hey, we've got a cap on our liability unless the seller committed fraud or gross negligence or committed some act that they need to be responsible for. And so that's a way to say, hey, there's a cap on certain issues, but not all of them, not all of them. And that's going to be with carve outs, as they're often referred to. And lastly, I want to mention survival periods. And that's kind of how that is, I should say, how long the indemnity obligation lasts. If we're silent on that issue, it would last the statute of limitations, which generally speaking isn't longer than 6 years, but 6 years is a long time. Some of them are 3 years, but generally for written contracts, it's 6 years, and that's how long that indemnification obligation be floating out there. Again, you could be fully paid for the sale of the business, but still have that obligation hanging out there. So with the survival periods, we can limit them. Sometimes they're limited to 12 to 24 months for general claims, but certain claims, such as maybe a lingering or potentially lingering environmental issue, could be a tax claim or intellectual property claim. Maybe those would be for the statute of limitations. So there's a threading that really occurs throughout the various claims that may fit a certain situation, certain sale that can be limited to maybe 12 to 24 months. Others are for a little longer. And all these are kind of a way to balance I don't want to say rights, but almost the comfort that the buyer and seller can get out of indemnification clause going forward. Buyers, of course, like them because they don't want to be on the hook for something the seller caused. But there's a good way to slice that up, and that's with these various provisions and various terms of art. So if you have any questions about this, I'd be happy to chat with you. Again, my name is Michael Kvistad. You can email us at info, I-N-F-O, at beresfordlaw.com. Be happy to talk with you if you have any questions. And I just want to thank you for your time. Thank you very much.